Welcome to Within the Frame, where we bring the most pressing issues across the globe into focus. I'm Kim Mok-yeon. Starting today, Korea becomes the first country in the world to enforce a national AI law. The AI Basic Act introduces legal standards for transparency, safety, and accountability while aiming to promote growth in the AI industry. Unlike the EU, which delayed its AI regulation, Korea moves ahead with rules for high-impact AI, mandatory labeling of AI-generated content, and a one-year grace period for companies to adjust. But the law is already facing concerns over vague definitions, possible overreach, and its impact on startups and content creators. So what does this law actually change beginning today? For answers to this, we connect to Song Se-ryun, professor of law at Kyung Hee University. A big welcome, Professor.
Thank you. Good to join you.
And also joining us is Park Jo-young, professor of Graduate School of Culture Technology at KAIST. Good to see you, Professor.
Thank you. Thanks for having me.
So let's begin a discussion right away with Professor Park first. So like I've said today, South Korea became the first country in the world to fully enforce a national AI law. Could you tell us what is the significance of being the first to do so, and what kind of global responsibility or expectations comes with that?
Yeah, so since even before the EU had theirs enacted, Korea has become the first one to pass a major AI law among the technological and economic powerhouses. And so the world may now start watching Korea because it could be a test case for whether such dedicated legislation can bring about any positive changes or outcomes regarding AI development and safety. But also taking an unprecedented step like that is bound to require some trial and error in the interpretation and the practical implementation of the law. And the government is trying to clarify some confusion on the ground regarding the concepts and the plans laid out in the law. So everyone should be watching closely for the implications of this law on the industry as well as the consumers.
Right. Stepping out for the first time definitely raises the stakes globally. But now that the law actually took effect today, people are wondering what they'll actually notice. So, Professor Song, could you tell us what changes immediately occur under this law, and what should the public understand as the most visible difference starting today?
Well, even though Korea is the first one to fully enact and put in force, but the discussion has been going on for a while. And in fact, EU actually took the lead on that. We just happened to be the one that put into effect first. The biggest change, I think, it's a similar approach that the EU had, the transparency and looking at the accountability part, and trying to see what kind of the regimes that we can have so that we can have a modicum of governance. I think that the biggest differences you would see is that on the transparency side, if any product or the service is originating from the AI, then they have to say that clearly. So the indication that certain product or certain aspect is generated by the AI, then that has to be clearly stated. I think it comes from the people looking at the AI and look at the problem, which is that even with the innovations, sometimes you can see things like deep fake and the pictures that you cannot really distinguish from the reality and the fake. So those kind of things, people look at it and say, look, this influence and the advancement of AI has created a vacuum of how to regulate it, how to tell the difference. So I think they're just throwing at the law at it. Korea happens to be the first one to do so, but those kind of problems probably will continue to look for solutions, however imperfect as it is now.
So, as Professor Song just touched upon, one of the most noticeable changes is the new rule on transparency, mandatory labeling for AI-generated content, especially for deepfakes as well. So, from a technology and content perspective, Professor Park, how significant is this labeling system itself, and how realistically can services comply across different platforms?
Yeah, so AI-generated contents, especially deepfakes, of course, can mislead through misinformation and sometimes flat-out lies, causing potentially grave damages, like innocent people getting falsely accused of indecency or crime. But the damage can also be subtle. So, for instance, AI music and video that steal from humans, hurting artists' living and the quality of art that produced is suffering as a result. So, requiring them to be labeled is a positive step, although currently there are some potential shortcomings that I noticed too. For instance, the mandatory labeling applies to AI tools and service providers, but those who generate the content from those can be exempt, like those making deepfakes, unfortunately. And so generally, it's not an issue of platform per se, though the video platforms will need the most attention. So for the policy to work, some heavy penalties on those producing harmful content in deepfakes will have to follow as well.
Right. So how it's going to be, the standard of how it will be categorized would be very important moving forward. But now that brings us to one of the law's most debated concepts, the category of high impact AI. So Professor Song, when we speak legally, what qualifies as high impact AI under this framework?
As you said, it is the most important area, arguably, because we have seen the growth and the advancement of AI, and a lot of people get scared by it. It's influencing just about everything in this world. And then the question is, if it is impacting the key areas of our lives, securities, education, employment, what should we do about it? I think what's telling is the approach that the European Union has and the Korea has. They look at the high impact area. The EU tries to kind of regulate it in a way that they would list it so that the taxonomy of it is that the European Commission will take the lead and kind of spell out what kind of activities or what areas would be a high impact area. Korea is a little bit different. It's a little bit vague, but try to see what kind of impact it would have in fact, so that the downside of it is that people have a hard time interpreting what that impact is in the absence of a clear designation of areas or activities. So it's a little bit different approach to solve the same problem. EU, because they have 27 countries, they had to be pretty precise about what that word means. But in Korea, they took the route of just defining what the high impact area could be in terms of the symptoms, but probably look at the impact afterwards and in a little bit of a hindsight decide whether certain activities are high impact areas. So approaches are different, but both regime have the same kind of concerns, the same kind of the problem
Definitely.
statement.
So when we don't have a clear definition of the level of impact, enforcement would become quite tricky for our part. Now, when we break that down a little bit further, the law considers factors like autonomy, risk level, and domain of use when classifying high-impact AI. So, Professor Park, do you think these kinds of criteria are practically applicable to real-world AI systems?
Yeah, I think this is the most critical question of all. So from a technical point of view, applying such criteria to real-world cases often run into real-world issues that are not intended. So we'll have to be willing to make corrections as we go on, obviously. So among them, I'd be the most interested in how the human involvement factor will affect the designation process of what is high-impact AI and what is not. So the law defines high-impact AI as those concerning important areas like energy, security, education, and the like, as Professor Song has pointed out. So far, so good. But according to the administration in one of its briefings yesterday, I read that when a human is involved in the final decision-making process, the government will not be considering it as a high-impact AI and therefore not subject to set regulations. And this actually is potentially something that has to be fixed in the long term, because it means if you run an AI all the way, then having a human at the end to decide whether to use it or not would simply make it not high-impact AI. The problem is that first, AI is not designed to allow human review of all its workings. So the final human decision maker is likely too poorly informed to make a decision. Second, if the human trusts AI too much and just accepts it, the human is not truly involved in the process at all. So the AI is, for all intents and purposes, high impact as defined by the law, but is exempt from the regulation. So this is a symptom of the broader issue of the first version of the law still not being very specific with many uncertainties, and we'll have to keep an eye on it.
Right, it's quite interesting. So it's not just about the field, but also about how much control AI actually has over the decision. Now, well, with all this, naturally, this classification, it raises concerns for many in the industry, especially for small players. Professor Song, what are the most pressing legal or structural concerns you see with how the high-impact AI category is being rolled out?
Well, it is being rolled out and has an impact that are felt in different ways. For example, if you were a startup companies, probably what you're concerned about is what kind of impact it would have on their businesses. And if it's the research areas, probably they'll be concerned about what kind of restrictions would they have in terms of determining and deciding and putting an investment in a certain the research projects. For small businesses, I think in an economic sense, the biggest question is whether this innovation and the regulation would have a positive impact or not. Usually they have a negative impacts between each other. If there's too much regulation, then the innovation spirit is chilled or downsided, or vice versa. So that's why the United States, more a market-based economy, they try not to regulate these activities, but the European Union and Korea certainly, there are a certain tint of social engineering spirit alive. So sometimes we see that the legislators take quick steps to get to regulation. So I think that the business community is a little bit negative in their attitude about this kind of laws, because these regulations will sap the innovative spirits. I think it is ultimately a balancing act, and we'll probably see some movements on the business communities and the legislators, depending on which aisle they sit in, to see whether this regulation move is to be strengthened or the curbed.
Right. So considering the complexity of this issue, then more corrections would likely occur moving forward. But let's stay with the practical implications first, especially for content creators. The law allows lighter disclosure rules for internal platform use like chatbots, but tightens them for anything shared externally. Professor Park, does this two-tiered approach strike the right balance between protecting users and encouraging creative freedom?
Yeah, so it's meant as a dividing line between a real-time service and what can be stored in one's computer and leaked onto the internet and live on. But there are some issues to be resolved here as well, I believe. So first, chatbots are quote-unquote inside a service, so you only need to flash a badge that says AI. But the problem is that the ill effects of false information and bad, psychiatric advice from chatbots are present in the outside world. So just because it starts inside service doesn't mean it deserves a lighter regulation by itself. So we have to be a little more careful in saying they are safe because they're inside the service. And second, there is this thing called screenshots or screen recordings on even the most basic devices. So the distinction between in-service and downloadable content is sort of fundamentally unclear. So even if you force watermarking on the second type, anything in the first type that is copied and saved can just as easily be distributed outside without any watermarking. So it seems a bit early to say whether it has achieved a final ideal balance between protection and freedom, because there's still a major highway around it, as I see it. So how it will be enforced will be something to keep an eye on as well.
Right, definitely. Which also raises the issue of legal responsibility. The law puts the burden on AI service providers, not users, when it comes to safety and transparency. So, Professor Song, is that legally appropriate, especially in cases involving, misuse or harmful content like misinformation or deepfakes?
Well, it's one of the principles of, having a historical background. I mean, when there is a harm, some sort of harm or injury in certain activities, and we don't know what it's about, then rather than looking at the specific or the exact legal principle to gauge it, we look at the big picture and see, hey, who can bear the burden more appropriately? Is it going to be an individual, or is it going to be a business or bigger organizations? I think in this sense, the law would decide that rather than the individuals, the platform business communities with a deeper pocket and more organized and more resources probably is a better actor to observe that kind of uncertainties at this point. It's the same kind of analogy when you talk about the product liability. If a business produces a product and certain harms spring from it, then the presumption is that it is the firm's fault because it's better to ascribe the accountability to the actor who can observe it and do something about it rather than the individuals.
So as for now, the burden is on the platform itself. No, then this law, it also applies to foreign AI firms serving Korean users like Google or OpenAI. But Professor, can Korea realistically enforce these provisions against global, big tech companies? And how does this affect domestic firms competing under the same law?
Well, on surface, we have to say that, well, within the territorial boundaries, the Korean government, the Korean legislature have the jurisdiction over the foreign multinationals who come in and do businesses in Korea. But of course, as you hinted, their global reach, their influence, probably it's going to be a difficulty for a Korean government to regulate them and do something about it. But the Korean regulators have the power to curb or decide what kind of market access they could have. So I think to a limited degree, I think the Korean rule or Korean exceptions can be applied to the global firms so that it's going to protect better of the interests and even the securities of Korean nationals. But I think it's going to be a battle because the market forces probably is on the side of the big multinationals, but the domestic interest certainly is something that the Korean legislators have to guard.
So it seems it's going to be a big test moving forward. But finally, stepping back a little bit, this law is positioned as the foundation for Korea's global AI leadership. So in the long run, how might this law shape Korea's AI ecosystem, its public trust in tech, and its place in the global AI race, Professor Park?
Yeah, so one part of the law is about the control of and freedom for the AI industry that we have discussed a little bit. So there are some issues to be ironed out, but that's one part of it. But the other part is that the law shows the administration's eagerness to promote AI as a major industry. And it does read like essentially a government-led multi-year development agenda that gives itself a lot of power and authority to pursue it. So huge investments will be made based on it with serious economic consequences. And one of the things I'm interested in is the 60-person steering committee that actually is written in the law that says will be formed to make such powerful decisions because how it's run will be crucial in deciding whether we have sensible, good AI technology as a result. Because from a fundamental scientific point of view, the AI at large has yet to deliver the type of tech it has been promising for years. And especially the generative AI sector has not even turned much profit globally. So there's some risk to it. So a success of this ambitious agenda, if you can achieve it, it's great. But if it fails, that actually could cost the citizens of Korea dearly. So it should represent all the interested parties, not just the industrialists or the industry, but also the consumers and expert citizens who can actually steer it to a reasonable decision or reasonable direction. So actually, the AI can actually serve the people with their needs and become actually a good technology.
Right, so it's clear this law isn't just about tech, it's about trust, leadership, and long-term direction of the nation's AI industry. We'll have to conclude our discussion right here, but thank you so much for your insights, Professor Park.
Yeah, my pleasure. Thank you.
And of course, Professor Song, we really appreciate it.
Thank you.
And that'll be all from us on Within the Frame. Be sure to tune in again next time as we continue to explore the stories that matter. Till then, stay informed and engaged.